individually and on behalf of TTLA, testifying respectfully in opposition to the bill. I want to thank you, Senator Schwartner, for giving us the opportunity to provide written comments regarding our concerns about the bill. And for today, my focus is going to be mostly on the repeal of 18001 sections F and G. The repeal would essentially wipe out the streamlined process of being able to prove up reasonable and necessary medical bills through sworn affidavit testimony by healthcare providers. Over 40 years ago, this legislature addressed 4 policy concerns by instituting the affidavit process to include facilitating undisputed testimony relating to medical bills. Number 2, reducing costs of litigation and reducing delays clogging courts regarding disputes of discovery over medical bills. And finally, trying to avoid a creation of burden on our healthcare providers so they wouldn't have to be giving depositions and live trial testimony. So there's a procedure in place at the moment with the controverting affidavits, which insurance defense lawyer can file that doesn't just, those affidavits aren't just filed against people who don't have insurance. We're seeing controverting affidavits even for patients who have comp or patients who do have insurance. That affidavit requires a qualified and reliable expert to testify as to the basis as why they are attacking the reasonable and necessary medical bills. So under this bill, all the insurance defense lawyer would have to do is provide a email or a letter indicating that they have a notice of intent to controvert the affidavit without expert testimony, without a basis, without grounds, and that essentially would nullify the healthcare provider's affidavit. The problem with that is that would then trigger the plaintiff to have to depose the healthcare providers or call them live at trial. For those, for example, Texans who are the most catastrophically injured, if they have 100 providers, from starting with life flight all the way to ER doctors, surgeons, anesthesiologists, to skilled nursing, rehab facilities, they would all have to be deposed to be able to testify as to the reasonable and necessity of the medical charges. So this would also potentially lead to just an automatic notice of intent to controvert the bills that would create a slippery slope. So there are already procedural and evidentiary mechanisms in place if there are untoward agreements, and that would provide a level playing field or do provide a level playing field for all the parties. With that, I want to express that we look forward to the opportunity to engage in an effort to try and find a solution for all. I'm happy to answer questions.
Ms. Thomas, thank you for your testimony. Senator Powell, you're recognized.
I just have one question. The scenario that you describe leads me to ask this question. Do you think that increase in regulation of our Texas doctors would have the impact of causing doctors to leave the state of Texas to do their practice?
Well, I believe I can say this, is that there are already some doctors who will not take injury cases. But some doctors don't have a choice, or some hospitals, if someone shows up at the emergency room and needing care, they will need to be treated. But as far as leaving the state of Texas, I can just say that it will cause so much red tape that there will be a loss of access to health care for many Texans.
Thank you.
Thank you, Senator Powell.
Thank you, Senator Powell. Senators, any other questions for the witness? Thank you, Ms. Thomas.
Thank you, Mr. Chairman.